Welcome to the Dealmaking with Laura DiFrancesco podcast. I'm Laura DiFrancesco, your host. We're talking all about mergers and acquisitions, buying and selling small businesses, as well as corporate law. We are taking our experience closing over $10 billion of transactions since founding Dean Street Law 5 years ago, and my experience being an M&A and corporate attorney for over a decade and making it accessible to you as an entrepreneur. I hope that this helps you in navigating the complex world of mergers and acquisitions. And also, we're always happy to be a resource for you here at Dean Street Law. You can always apply to work with us through our complimentary consultations linked in our show notes. And a huge shout out and thank you to everyone who's subscribed and left us a 5-star review. If you haven't yet, be sure to subscribe and also leave us a 5-star review. It's one of the best ways to support us as a small business. And also be sure to share with your friends and colleagues on social media, through text, email, or however is easiest. It means the world to us that you're supporting our content and helps us make more to support you in your journey. Welcome back to another episode of the Dealmaking with Laura DiFrancesco podcast. I'm your host, Laura DiFrancesco, founder of Dean Street Law. Today, I'm excited to be talking about using escrows and holdbacks in M&A transactions. So whether you're buying or selling a business, this will be helpful for you. I think before we start, it's really important to have a good understanding of what is an escrow, what is a holdback, what is an escrow holdback. So an escrow is when funds are held by a third party in an account that needs to be determined how it will be dispersed between the parties. So think of an escrow being held by a third party. That could be a deposit is held in escrow, certain amount of funds related to the transaction. For whatever reason, it could be for indemnification, working capital escrow. Whereas a holdback is where you have a portion of the purchase price is held back from being paid from the buyer to the seller. Now, generally, a holdback without any other information may be just withheld and not paid into escrow. But then you consider an escrow holdback is when the buyer pays that portion of the purchase price into escrow and then it is held back from disbursement to the seller unless certain elements are met, certain terms are met. So when you have an escrow, consider that to be controlled by a third party. When you have a holdback without any other information, it's generally held by the buyer and not paid yet. And then escrow holdback is when it's paid by the buyer but held in by the escrow agent. And so it can be confusing when you're talking about these things, but the most important thing is to have clarity between the parties of what the expectations are, and then having your attorneys document it appropriately so that what you think you're saying is what you're saying. So first, I think one of the second most important things to talk about beyond just mechanics of what are these things is what information can you trust when you hear that these are the percentages to expect for escrow holdbacks or indemnification escrows or working capital escrows or anything like that? There are a lot of literature and studies on what is market, what the deal terms usually are from deal to deal. With that said, one, the quality of those studies are entirely dependent on the information that they receive and who is submitting that information. And I have done billions of dollars of deals and have never submitted any information to any source as to what the deal terms are on any of those deals. And I know when I was working in big law, we were also not submitting information on deal terms. So those deals and those studies are one elective of certain parties disclosing certain information. And so it is heavily weighted based on what the collection and data sample is. And then two, the deal economics change so drastically and deal terms change so drastically from deal to deal. And from deal size to deal size. I mean, if someone tries to throw out, well, this is the general percentage that I see in escrow holdbacks, and it's like based on lower middle market deals that are 50 million to 225 million, it's absolutely irrelevant to a deal from 1 to 10 million. And honestly, deal economics and deal stats from deals of 5 to 10 million are almost irrelevant on deals of 1 to 2 million. So first off, you really have to understand how to think of those deal stats. And then also, once you have them as general information, you throw them out the window, because they're so irrelevant to your deal itself, because your deal specifically is going to have a different set of circumstances than any other deal. And so for many reasons, they are just data and information to help you make decisions, but they are not the end all be all. So when you're thinking of escrows and holdbacks and the amount that they should be and what deal stats say, you really have to consider, is this a competitive situation? Am I negotiating this LOI and there are 5 other interested bidders or interested parties? Or is this something one-on-one where they're really a little bit more hesitant to sell to just anybody and they're really only focusing on you? Because when you have negotiation leverage in a deal, drastically is going to impact the deal terms itself. Because if you have negotiation leverage, then you may be able to negotiate more favorable terms, whether you're a buyer or seller, than if you don't have negotiation leverage. And so that is something that plays a huge part. And then the other that plays a massive part is the actual business that we're talking about. There are very different liabilities and potentials for liabilities in a direct-to-consumer white label business, where it's basically just an Amazon product that's being white labeled and sold, and it's not something that has to be used for medical purposes, right? It's just a regular old consumer good that's not going to have really any impact on people in terms of liability, right? Versus a hazardous waste processing facility. Those are 2 entirely different companies to compare their risk. And you have to also, when you're thinking about these things, also think about what insurance is there available as well. What is an insurable claim versus a non-insurable claim? If there's indemnification, what is the indemnification actually going to materially cover? Is there workman's comp insurance? Is that adequate? Are there really massive pieces of equipment? A deal that I'm currently working on has a piece of equipment that has $1 million replacement value and another piece of equipment that has a $750,000 replacement value. I know of another company that we've worked with that has $3 million piece of equipment. So when you're talking about indemnification, yes, we can do a inspection of those to see what is the current status of them. But to a certain extent, if you're buying a piece of equipment, if you're buying assets, if you're buying a business, you are buying them with the expectation that the reps and warranties are accurate. And so if there are inaccuracies that are not insurable, those are especially going to weigh into the fact of how much should be in escrow or not. Same with working capital. If it is a business that is really, really easy to identify what the working capital is because they have 1 or 2 transactions a day, that is vastly different than a business that has 35 or 30,000 transactions in a day. I don't know if they're going to be having 30,000 transactions a day, but there are those companies and we've worked for them. And so when you're thinking about whether you need an escrow for the working capital adjustment, it depends heavily on how certain you are, whether you can even finalize that working capital adjustment prior to closing. Some certain companies that's possible, or if it needs to be a certain amount of time post-closing. And if it does need to be a certain amount of time post-closing, should there be an escrow related to that so that that's not something that needs to then be taken back from the seller or something like that. So these are so hyper dependent from situation to situation, and those elements and differences are really important in allowing the parties to feel comfortable. Ultimately, these are all mechanisms for risk mitigation, and they're also mechanisms for creating, on the buy side, protection from breaches, financial discrepancies, contingent liabilities, and they're also to create an easier mechanism for post-closing adjustment, whether that be sometimes there's an escrow for earnouts, sometimes there's an escrow for working capital adjustments, indemnification. So all of these are different elements and deal terms that are going to be negotiated on a deal by deal basis. And then also it can be very aligned for both parties, and there can be really good middle spots to align on, whether it's the survivability time period of an indemnification escrow or the amount of the indemnification escrow. Generally how much that percentage is going to vary considerably from deal to deal size to deal size. And when you consider the amount of these escrows, the durations, and the release conditions, those are going to be generally your three biggest negotiation pieces. And there are general, like you can see in the well done deal stats, you will find some information on this, but again, you have to really consider it from the deal that you're actually working on right now and what makes sense and what the parties feel comfortable with, because ultimately the deal terms are what one person and another person agree to, and that's what it is. When it comes to navigating corporate law, entrepreneurship, and managing small businesses, experience matters. Dean Street Law is a boutique corporate firm specializing in mergers and acquisitions, and additional focus in real estate, commercial transactions, finance, and corporate governance. With over $10 billion in deals closed, Dean Street Law has extensive experience representing hundreds of clients in thousands of transactions, from small businesses to Fortune 500 companies. Whether you need startup guidance or advice on closing multi-million or multi-billion dollar deals, we're your trusted partner every step of the way. Visit deanstreetlaw.com in the show notes to schedule a complimentary consultation. And then with escrows specifically, you have an escrow agent, and you always need to have some sort of escrow agreement with that escrow agent that will define their role and also set forth the terms of the funds being held in escrow. Now, generally, if those funds are certain parties, so most of the situations we've talked about, those funds are to be paid to the seller contingent upon certain information, like a working capital adjustment contingent upon the payment of the working capital, and the disbursement accordingly, and any adjustment that needs to be made therefrom. So when you're thinking about who earns, if it's an interest-bearing account, it would generally go to the party who is ultimately going to be dispersed those funds absent any sort of adjustment. And those are, though, highly negotiable, what percentage that's going to be, whether the escrow agent must hold those funds in separate accounts so that it's not aggregated with other funds, whether it needs to be an interest-bearing account, whether it can be invested, how the determination of the release of those funds are going to be determined, are all going to be set forth in both your transaction documents as well as your escrow agreement. So you have to make sure that when working with an attorney that both of those elements are covered, because you want to make it as clear and simple as possible. It shouldn't cause litigation. You don't want it to cause issues in the future. You just want this mechanism to work well and to be easy to facilitate. So those are all important aspects to think about when you're negotiating escrows, holdbacks, escrow holdbacks, and everything in between. I hope that this episode has been helpful. Please be sure to subscribe, and I will see you in the next episode. And before I let you go, do not forget, if you're on the buy side or if you're on the sell side and want a little insight as to buyers buying and selling businesses, I highly recommend that you go check out my book, Entrepreneurship Through Acquisition, A Legal Guide to Buying a Small Business. It has so much great information on the legal aspects of buying a small business. You can access the first chapter on my website and linked in the show notes. It's also on deanstreetlaw.com/links. And you can leave me a 5-star review. It would mean the world to me. Of course, pre-order and order your copy as well. And when you leave a 5-star review, you can send it to etareview@lauradifrancesco.co to receive a pre-LOI due diligence request list. So thank you guys so much for your support of the podcast. It means the world to us. Thank you for sharing on social media, tagging me, but especially also thank you for supporting my book. If there's anything that you want to hear in a future episode, a topic you want us to cover, I would love to know. Be sure to follow and subscribe for more. Take care, cheers, and happy deal making. Thank you so much for joining us on this episode of the Dealmaking with Laura DiFrancesco podcast. I hope you found today's discussion insightful and that it brought you one step closer to mastering the art of